So we have some important news coming out of the Supreme Court. The Supreme Court just denied review to a case which sought to strike down ammunition restrictions, primarily background checks on ammunition. So let's talk about what just happened. Now, really quick before we jump into this video, if you agree it's time for the Supreme Court to strike down more gun control laws, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FPC, GOA, SAF, and others. So if you want to support the 2A cause and get great coffee, check out Blackout Coffee using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So as I mentioned in the intro, I have some important news coming out of the Supreme Court, and this is some news that I think is very relevant for a lot of people, not just in the state of New York, but other states like California, where we suffer from restrictions in gun control that regulates ammunition, primarily the purchase of ammunition without background checks. The Supreme Court today issued an order in their order list, and out of that order list, there was a denial of review to a specific case. The Supreme Court has denied emergency review to a case called Gazzola versus Hochul. This is a case that we've talked about before on the channel, and it's a case that is directly resulting from the state of New York passing the Concealed Carry Improvement Act, also known as the CCIA. This case here challenges the state of New York and them putting in place the Concealed Carry Improvement Act, that CCIA law. Primarily, this is a challenge to a lot of the restrictions that gun dealers and FFLs face because of the CCIA. This one specifically is challenging some of the ammunition restrictions as well, like you having to run a background check for all ammunition purchases. The Gazzola case focuses on the impact that CCIA law has specifically on dealers and the impact that it has in regulating the right to keep and bear arms and the downstream effect, because here what New York wanted to do is essentially regulate not only the access to permits, the ability to concealed carry through that law, but then they also targeted gun dealers. And the hope was that there would be downstream effects where if it makes it harder to get access to firearms and ammunition, well, then the individuals cannot exercise their Second Amendment rights. So that is what's being challenged here in this lawsuit. Now, in this specific case, the Gazzola case, the plaintiffs were once again going to the Supreme Court and asking for the Supreme Court to step in on an emergency basis and strike down primarily some of these restrictions that they have on gun dealers through the CCIA. Primarily also one of the things that they were focusing on, like I mentioned, was background checks for ammunition. Before in this case, the plaintiffs in the Gazzola case had gone through the process and had filed for emergency review to the Supreme Court. But on that first attempt, the Supreme Court also denied emergency review in this case. So what ended up happening kind of at the lower court level is the lower court denied the preliminary injunctions. Then the Second Circuit was set to review this issue. That was, the Second Circuit kind of stalling and not doing what they were supposed to do. That then led to that first attempt for Supreme Court review. The Supreme Court denied emergency review at that time, so then the Second Circuit was allowed to issue their decision. Now, there was a bunch of other cases coming out of New York which also challenged the CCIA. There are a lot of cases that we've talked about, including the Antonyuk GOA lawsuit. And with the Second Circuit's review of all of those cases, what ended up happening is the Second Circuit said, in summary, that Bruin and the decision by the Supreme Court in Bruin does not apply to the CCIA. The Second Circuit tried to distinguish Bruin from what was going on in cases like Antonyuk and Gazzola and some of these other lawsuits. The Second Circuit there said that Bruin was an exceptional case, and it dealt with an exceptional restriction that New York had put in place prior. But this new law, the CCIA, which again was passed in direct response to Bruin just 8 days later, creating an even more hyper-restrictive concealed carry restriction and new laws like ammunition restrictions, even though that it was more hyper-restrictive and a direct play on what just happened in Bruin, suddenly the Second Circuit said, well, Bruin doesn't apply. This case here, the CCIA, Gazzola, Antonyuk, and all these other cases are not exceptional like Bruin. And so what ultimately ended up happening in a lot of these cases in the Second Circuit is the Second Circuit reversed the injunctions and some of the decisions that happened down below that were positive, or upheld some of the negative decisions that happened. And so ultimately the state of New York won a lot of those lawsuits. And out of that Second Circuit decision, what then happened is a lot of these cases went back to the Supreme Court on an emergency basis, asking for the Supreme Court to step in early and strike down and reverse what the Second Circuit said. Not only was the Gazzola case seeking emergency review, but then you also have other cases like the Antonyuk case that were also seeking a reversal of what the Second Circuit ruled. Now, keep in mind what is going on here in all these lawsuits is it is an emergency review and it's an interlocutory review. And the reason why I'm saying that is because all of these cases deal with preliminary injunctions. These are not final merits decisions. These are not motions for summary judgments that were granted. These are not, final reviews after a full hearing and evidentiary basis. That is not what's going on here in these cases. These were all plays off of preliminary injunctions that were requested by organizations like GOA, FBC, and others. Then there were decisions on preliminary injunctions that went to the Second Circuit. Second Circuit reviewed those. And now what the Supreme Court will review is whether or not those preliminary injunctions should have been granted or not. Now, that's not to say that these preliminary injunction reviews are not important, because they are very important. Not only do preliminary injunctions stop the enforcement of various laws while a lawsuit is moving forward, but also when a court rules on a preliminary injunction and they apply the standards for preliminary injunctions, it signals and pretty much sets the precedent for how the case is going to move going forward. If a court agrees that there is a likelihood of success on the merits to grant a preliminary injunction, that often signals that on the final merits decision, they will in fact rule in favor of the pro-2A side or the anti-gun side. And so it just kind of sets the standard going forward. And often whatever side wins the preliminary injunction, soon after you will see them file something like a motion for summary judgment to try to win the case outright before going to a trial. The plaintiffs in this case were once again asking for the Supreme Court to step in early and reverse the Second Circuit's reversal of the preliminary injunction. But for the second time, the Supreme Court has denied review to the ammunition background check case. However, I will state that all hope is not lost, mainly because of what the Supreme Court is doing in a different case, which deals with the CCIA. And it's a case I just mentioned, which is the Antonyuk case. We've talked about on a prior video, just the last video, that the Supreme Court has put the Antonyuk case on hold. And why they put that on hold is likely because they are going to issue that decision in Rahimi, and Rahimi is going to be the next big 2A case, which is applying Bruin and that analysis to the federal restrictions on the possession of firearms and ammunition when it comes specifically to people subject to domestic violence restraining orders. What the Supreme Court is doing here in putting the Antonyuk case on hold is signaling that Rahimi and that analysis will impact other cases, and it will impact cases that need to apply the Bruin standard. And also they're saying that, hey, the CCIA is going to be impacted in some way by Rahimi, and therefore we're putting Antonyuk on hold. And then probably what's going to happen after they issue Rahimi is you will see a grant, vacate, and remand of Antonyuk. And again, Antonyuk deals with a broader challenge to the CCIA. Gazzola also deals with a challenge to the CCIA, its constitutionality, its analysis of Bruin, and what the Second Circuit said about how to apply Bruin. So although Gazzola was denied review, you have the Antonyuk case on hold. You have the Rahimi case coming very soon. After the Rahimi domino falls, you will see the Antonyuk domino fall. Then very quickly, you'll probably see that GVR and whatever language is applied to Antonyuk or Rahimi, then also cited in Gazzola. And then you're probably going to see maybe a reevaluation of Gazzola, Antonyuk, and all these other cases by the Second Circuit. And the hope is that there's going to be strong enough language in Rahimi to correct these issues. So for those keeping track, Gazzola was one of those cases that was seeking emergency review of the CCIA. It went to conference on June 13th. We got the order list this week. The order list of the Supreme Court denied review to the Gazzola case. But as I mentioned, not all hope is lost. But as of right now, what we can say is the Supreme Court has denied review to the Gazzola case. Once again, they have decided to not review ammunition background check systems. They've decided not to strike them down as of right now, but I think there is going to be a lot of positive things developing going forward. So for now, we're going to have to watch how the Gazzola case moves forward in New York, and then the Rody case moves forward in the Ninth Circuit challenging California's ammunition restrictions. And of course, if we get any more information, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.